I think a big thing that's been very present now is AI. I was very lucky to stumble upon this and really get into this in the beginning of my career.
A very curious question, why a JD plus an MBA in finance?
And, it's funny because being honest, I was actually thinking about even pivoting out of law at that time. I use AI as a tool, right, to assist me sometimes, but AI will make things quicker, but you need to know what you're doing. Thank you so much for having me.
Welcome everyone to the second season of SEC Reporting Journal, brought to you by Finrep AI, a purpose-built AI for financial research and reporting. I'm your host Gana, dialing in from San Francisco. Today I have with me Gabriel Miranda from San Diego. Gabriel is a capital markets attorney at Michelle Silberberg and Knopp LLP, focusing on microcap and small cap companies. Gabriel has a fairly unique profile where he has a JD and MBA in finance, and he speaks fluent Portuguese and conversational Spanish. He has extensive experience with IPOs, uplistings, direct listings. He represents clients in security laws, mergers and acquisitions, and corporate governance matters. He also advises public companies to comply with their obligations under Act 34, including annual, quarterly, and current reports and proxy statements. Welcome, Gabriel. Can you help us walk through the career path that you have taken? What has brought you to where you are? What drew you to securities and capital markets? And a very curious question, why a JD plus an MBA in finance?
Yeah, Gana, thank you so much for having me. Excited to be here and talk a little bit about myself, about the industry, and a little bit about what I do. I think that SEC reporting is something that, it's a collaborative effort altogether, right? So it's interesting to get different points of views on this. So, with regards to my career, I started in-house actually, right? So I worked at a Fortune 500 company during law school. It was my third year of law school still, so it was an externship. And at the time, I was actually doing commercial contract review there, but the assistant general counsel was able to pull me into the SEC reporting type of work. So that was really my first exposure to 10Qs, 10Ks, Section 16 type of filings and things like that. And, they are a very big company, so they had a very robust team put in place in charge of working through SEC reports and things like that. I was very lucky to actually stumble upon this, I think, because I was in Miami, right? I went to law school in Miami. So this type of work of securities and capital markets is not as common as places like LA, New York, Boston, right? Where a lot of those positions are present. And, I was very lucky to stumble upon this and really get into this in the beginning of my career. From there, I was able to leverage a position at Greenberg Traurig, continue working with SEC reporting there. And then at the time I had a student visa actually, so I was only able to work there for about a year. And then after that, I did my MBA. And, it's funny because being honest, I was actually thinking about even pivoting out of law at that time, which is why I got my MBA. I thought that if I went back to practice, it would give me a business side view of things more than just the legal side. And it would also give me a little bit more accounting experience, which I think that it's an underrated skill for our capital market securities attorney, because a lot of times when we're looking at SEC reports, maybe some attorneys wouldn't necessarily be looking at financial statements, but we make sure that, I have, from experience of reading others, but also from my MBA, I was able to understand more of the accounting side of things, right? And then after my MBA, I worked at Lucosky, and that was at the height of COVID, right? It was 2021. So I was able to get this position remotely. And they are a firm that's located in New York, focusing on microcap and small cap companies. And on that portion of my career, I got a lot of capital markets experience, did a lot of deals, IPOs, which complemented really well my SEC reporting experience from before. And of course, since then, been at MSK for now 4 years. And, it really was happenstance that I ended up in this career. I think that in Miami, a lot of people become litigators. So I was really happy to actually be able to start there and obviously continue my career in this area. And I think that a JD MBA together really offers me more value to clients, right? I think that I work with a lot of small cap and micro cap clients that they don't have 50 accounts working on the financials, right? So sometimes these companies go public and they really don't have a robust team in place. So I think that being able to give that direction sometimes, look, we're not accountants, right? So we can't really give you accounting advice, but from our experience and from my own accounting knowledge, I'm able to point to clients sometimes things that we see in the financials that are not, currently present there, or an accounting treatment that I'm like, oh, I've seen this differently. So I think it gives the client a little bit more value from what we can provide as attorneys.
Awesome. So you end up advising companies, C-suites, boards on security law and governance. For the audience that we have, which mostly knows accounting side of reporting, can you help describe in detail what does a capital markets and securities lawyer actually do on a day-to-day basis?
Yeah, it depends on the day, right? I think that it's funny because if you look at even what I did this week, I worked a little bit on a SPAC IPO. I worked a little bit on a direct listing. I worked on a de-SPAC all in this 1 week. But if you asked me last week, I've worked on proxies and 10Qs and things like that. We're probably gearing up for another 10Qs soon for Q2. So it depends on the day and depends on what I'm doing, but I think we wear a lot of different hats, right? I think that, we sometimes are just simply advisors when a board of directors member or an executive has a question. We just give our legal advice. Other times we're negotiators, right? A lot of times for these deals that happen, we're the ones, taking the lead in negotiating underwriting agreements and business combination agreements and things like that. But I think we also serve other even administrative tasks because we attend board meetings, we take minutes, we prepare board resolutions. So I think that what we can do as securities and capital markets attorneys, it's a very broad range of things. You see sometimes attorneys that work mostly on deals, or sometimes attorneys that only work on SEC reporting. In my case at MSK, we have a full suite of services, right? So we depending on the client, we offer every type of service that they require in terms of corporate governance, corporate, general corporate services and things like that.
Got it. So most of our past guests actually help prepare these filings from an internal reporting perspective. You help draft these and review it from a legal lens. So for a typical 10K or a 10Q, where is the line what SEC reporting and accounting team owns, and what does an outside counsel own?
Yeah, interesting question, because a lot of times when we're reviewing these reporting, these periodic reports, a lot of my comments are, I just defer to the accountants, right? Because that's where the line is usually drawn. But generally speaking, right, the accountants are going to be in charge of the financials, financial statement notes, taking account accounting treatments of things. They're partly responsible along with management for the MD&A. So, and then, as legal counsel, we are reviewing pretty much the entire body of the Form 10Q, 10K, whatever it is, for compliance with Regulation SK, for example, and other SEC rules. But, I think that's where we can provide more value than sometimes other attorneys is. I myself, for example, I look at the financial statements themselves as well, because, like I said earlier, based on how we've seen so many financial statements at this point. So sometimes we see something that should be included there. Sometimes we know something that happened with the company, maybe litigation, maybe some other commitment or contingency that would have triggered an accounting thing under ASC 450 or something like that, right? I think that we're able, because we have that knowledge in accounting as well, to provide that guidance. Ultimately, we defer to the accountants, of course, but I think generally the line is financials, accountants, everything else, pretty much legal counsel and management.
Got it. From a diligence lens, where does legal most often catch issues that other people miss, and where do you rely on the other side to actually catch what you cannot?
For diligence, it's interesting because, obviously diligence, we're the ones that will be driving that, right? So the accounts are not as involved in that. But in terms of the SEC reporting itself, I think that sometimes it happens, for example, right? Management is always responsible for the MD&A, but we work with management closely to make sure that, Regulation SK compliance is met and that all the information is included there. But sometimes, accountants are able to catch something in the MD&A in terms of numbers or something that does not match with the financial statements that, that's why I like having accountants that are, involved with this type of thing as well, because it doesn't end at the financial statements, right? The disclosures and the numbers have to really be fit and be consistent with the financials. So a lot of times we like to have the accountants look at risk factors and even MD&A and other things to make sure that all flows through correctly. But, I think that it's a collaborative effort, right? I think that, accountants and legal and management, we all work together to the same goal, to have a filing that is complete, accurate, and, compliant with SEC rules. So ultimately, we're all driving towards the same goal.
And from a counsel's perspective, Gabriel, what makes a reporting team a pleasure to work with versus a painful one? Do you have some of the examples from past that you could go across and share, which would have been very interesting for our guests to go across and hear?
Yeah, I wouldn't use the word painful. I think that it's more interesting, let's say, to work with companies that, we work with a lot of companies that are small cap companies or companies that, went from startup to doing an IPO or direct listing. So, they don't have a team of 50 people working on the financials. So, sometimes it requires more of our advice and sometimes our guidance for these companies to put together 10Q. Sometimes we prepare even the initial 10Q for the company to actually fill those in as needed. So, I think that it's more interesting to work with smaller companies because we tend to be very involved in the whole process. And I personally like that. I've worked with some clients that, I've been doing their periodic reports for 4 years now. So we get to see the company growing and the different disclosures and how we adapt the narrative to be compelling, to show the growth of the company, to show what has changed in the last 4 years, right? So I personally like these type of clients because we do get to be very involved with them and we work directly with management, board members and things like that versus companies that, they're bigger. So we're doing the Form 10Q in terms of SEC review, but our involvement with disclosure is not as important as it is for these other smaller clients that really rely on us to give them the right advice and guidance so that they can be SEC compliant, compliant with their exchange listing requirements as well and things like that. So I personally like to work with these clients because we get to really go close with them and grow a relationship that goes beyond just business.
For a new counsel who is joining in and working on the SEC reporting with these teams, do you have some advice for them to how to make that experience really smooth, how to avoid hiccups?
Yeah, I think that, from the accounting side, I would say it's really important to be prepared and think, start thinking about things early, right? Right now we're almost done with Q2, so it's good for them to start thinking about closing out the books and start preparing the financials, because by the time the 10Q gets to us, we like to have a draft that we think is, almost final, at least in terms of the financials, because then it's just easier for us to work that way, right? We can point something out, but we're not asking the account to rewrite the whole financial statements or anything like that. I like to learn from them as well. But I think the accountants should but they should listen to lawyers as well, because sometimes we do have comments that, the accountants need to work with us to get them solved. So being able to listen and understand our comments and be collaborative in implementing those in the financials as well, I think that's a huge thing. I also think that, in terms of the team itself, right? We see a lot of these smaller companies that, maybe a CFO or the other accountants that are working with the company, they don't necessarily have public company experience, right? Like some of these CFOs are not even thinking about that type of thing while the company's private, right? They have a mindset more towards, developing business and raising capital and things like that. So, ensuring that your team, or even sometimes getting an advisor to assist with the transition, it's really important to be, especially when you're going public, to be really prepared for that transition. And then as you, evolve as a public company to really think about how to improve the team, how to maybe grow the team, and to make sure that the process goes smoother going forward.
Got it. Gabriel, on the deal side, you do draft the full registration toolkit and tender offers. For a company which is planning to go public and it looks like the current administration and the regulators want more companies to go public, what does a legal works team look like? And basis your own experience, where you have seen timelines usually slip?
Yeah, great question. It's IPO timelines and things like that. It's very discussed in our industry, and one of the most underappreciated things about being public ready is audited financials, right? A lot of private companies, they want to go public as soon as possible, but it takes. I think that the process to go public begins way before we're even thinking about drafting the Form S-1, right? It's making sure they have, robust processes in place. It's making sure they have your audit financials in place, because you don't want later to have a restatement or something like that that would really delay your IPO once you're already in the process with the SEC or something like that. So I think that's one of the things that private companies do not appreciate enough. That it takes a long time, and through no fault of the auditors, by the way. It's just a process that does take a long time, and a lot of work from management. They're going to have to be very present in the process as well, because of all the requests from auditors. So I think that's number one of the things that push timelines a little bit, because sometimes financials, they think it's going to take 3 months, take 6 months, right? So that's number one. So making sure that your company is in a place where you can start thinking about being public is number one, is making sure you think about corporate governance and all these things early on, getting perhaps an advisor to assist you with the transition, things like that. And then after that, once you really start in the process, that's where most of the time we come in, right? We have, the Form S-1 drafting, right, where we are working with management to do business section, risk factors, MD&A, which, while we're doing that, we're balancing, right, the legal side of it to make sure it's SEC compliant, but also, especially for IPOs, you want to make sure that the company is telling a compelling story. It's telling their growth story. It's making sure that investors understand what the business is. So it's really balancing those two things together. Can take a long time too, because, drafting a business section is something that companies sometimes don't do before, right, while they're public. So it takes a long time. And then concurrently with that, right, we're doing exchange listing applications, NASDAQ, NYSE, whatever. And I think those are the second bucket of things that can delay an IPO, right? SEC review after you file your first S-1, it takes up to 30 days, and then every other amendment takes up to 10 days. NASDAQ, especially now that we're seeing the NASDAQ is really making more restrictive to list, right? Or NYSE as well. They're both becoming more restrictive in terms of accepting companies to be listed, because, and I'm giving an example for NASDAQ, right? They now have a discretionary authority under a new rule to really deny listing for reasons beyond a company satisfying those listing requirements, right? So I think that really the question now is, does the company belong on the exchange versus does it meet the requirements? So I think that's a very important point for companies trying to think to go public now, because that is also something that can lengthen the process now, given where NASDAQ's rules are at now. And, and then obviously, while we're all working on that, we're also preparing corporate governance structure, right? We're preparing policies, clawback policies, inside trading policies, the committee charters, so all those things are happening at the same time. So, work stream is really a collaborative thing. We're working with accounts, we're working with the auditors, we're working with the company, we're working with underwriters, counsel, underwriter. So, that's why the process can take a long time, because there's a lot of parties involved. And, that's not even talking about an IPO of a SPAC, right? There's even more parties involved there. But so I think that, that's something that private companies need to be really cognizant about, is that it takes a long time and it takes a lot of preparing. And I think that especially the audit financials and SEC review and NASDAQ review are the three biggest things that companies should think about in terms of their timelines, to be realistic about it in terms of when they are actually going to go public.
Got it. You did mention SPAC, also that you are doing some work on them earlier in the week. SPACs went through their own boom and bust cycle a few years ago, and they seem to be coming back. Where you sit right now and have a macro view on the capital markets, what's the realistic state of SPAC and de-SPAC disclosure today, Gabriel?
Yeah, so SPACs, of course, they went through quite a run in 2020, 2021, right? We had a lot of SPACs, a lot of de-SPACs, and I think that it was somewhat of a perfect storm at the time, right? We had historically low interest rates, which kept redemptions much lower than they are now. We had a lot of retail investor enthusiasm around that time. So I think all of that really contributed to a huge boom in the SPAC market at that time. But what also happened is that a lot of the SPACs that did go public and did do these SPACs, given that the disclosure requirements were much less tight than they are now, right? They could do a lot of other things that they cannot do now, projections, and now disclosures they require more disclosure about conflicts and things like that, right? So, a lot of those companies that went public, I don't think they were necessarily the right fit at the time. I think that, there was a lot of enthusiasm about these SPACs, but some of these companies had astronomical valuations or projections that were not as realistic as they should have been, or even public companies that went public without, having a lot of that foundational infrastructure ready to even go public in the first place, right? What we talked about a little bit about earlier, which is public readiness, right? I think a lot of these companies maybe bypass that with the idea that SPACs can get them quicker to the market. And, that fact is true to this day, but, a lot of these companies at the time were not ready, I think, to go public, right? And I think that's the main difference we're seeing now. So in 2024, SPACs had heightened disclosure requirements now, and they are still applicable now for both IPOs and these SPACs that, really got into sponsor compensation, conflicts of interest, things like that, it allowed for more protection, I think, and more disclosure and more transparency for the SPAC market. But at the same time, I think it limited the amount of SPACs that were, going public. And although we are in a run right now, since last year, we had a lot of SPACs go public, I think that we're seeing a lot more disciplined approach at this point. I think that sponsors that are participating in the market, they're very experienced. They have genuine sector expertise and real relationships with targets. And that's why we're seeing a lot of serial SPAC filers, right? We're seeing a lot of the same SPACs going public time after time. And it's because a lot of these sponsors, they just have the experience, right? So I think that's what we're seeing now. A lot more disciplined approach for target search, a lot more expertise and experience for the sponsors. And I think a lot more realistic valuations for the targets. And I think personally that the pipeline for these SPACs from this round of SPACs is really encouraging. I think that, we're seeing these mega IPOs also happening, right? SpaceX, I think we have Anthropic and OpenAI also filed their confidential filings. We have a lot of, so I think that the pipeline for IPOs is really, I'm very optimistic about that for, the second half of the year and going into the next year. The pipeline for these SPACs, especially, I think it's really strong. We're going to see a lot of really strong targets going public. So, I'm very encouraged by that. I think that this time around it's going to be different. Obviously, there's still going to be companies that, may not necessarily, have as much success as others, but I do think that this time around will be different and much better than last time.
Can you walk our audience through how an underwriting or a merger agreement comes together under a deadline, and what often becomes the sticking point? I'm assuming you already mentioned audited financials. Would love for you to educate our audience.
For underwriting agreements, for an IPO or like any other public offering, it's a lot simpler than, for example, a business combination agreement for a de-SPAC, right? Because when you're doing a business combination agreement, you're thinking a lot about tax as well and a lot of other things, structure of the deal, jurisdiction of the deal, terms of merger consideration, right? So a lot more work goes into those in an underwriting agreement. So for an underwriting agreement, really it's just negotiating between us and underwriters counsel. A lot of times we get feedback on the company. in case underwriters counsel pushes back on something, we're like, hey, are you okay with this? Do you want us to push back? We give them a general sense of what market practice is. And I think that process is usually a lot more straightforward than BCA, right? Business combination agreement. If you're looking for a business combination agreement, though, we've literally seen BCAs and mergers fall through because of a tax issue, right? Where there's a negotiated BCA and something tax doesn't get resolved, and they just abandon the deal altogether, right? So tax is really important. The deal structure is really important. So these are the main things I think would come be a sticking point for that. Besides obviously the merger consideration, but I think that it's just a collaboration, right? I think the underwriters counsel, they're not necessarily opposite to us. Right? It's not the same as litigation where you have an opposing counsel. We all want the deal to work, but sometimes some deal points become really sticky to our clients sometimes for a reason or another, and that can make the deal fall through. You never know.
Around deals falling through and writing disclosures, how do you keep these risk factors from becoming boilerplate, and what actually drives an update?
Yeah, so risk factors, it's interesting, right? Because we think mostly about them on 10Ks, right? That's where you are doing your annual report. You are describing all the risks applicable to the company and its business. And a lot of the updates go into that filing. And the reason is, there's been a year from the last 10K, and there have been subsequent 10Q filings, and sometimes those 10Q filings will be updating the risk factors included in the 10K, right? Something happens in between, if there's litigation, if there's anything that happens in between the 10K and 10Q, we're gonna likely include an updated risk factor for that, or a completely new risk factor for that, right? And it's all driven by materiality, right? Is there a material risk that was not contemplated before in a previous filing that should be included in the 10Q, for example, after the 10K is filed? So we do that analysis every time, right? And sometimes even, there's an offering, right? And then a new risk arrives relating to that offering. So the offering prospectus supplement or prospectus or whatever is going to have an updated risk factor about that specifically. So it's all driven by materiality. And then once you get to the new year, the new annual report, we update everything again. But generally, it's all materiality, right? It's like, is it material to the company? Is it material to the business? Is it material? Is it going to impact the company in any material way that we should disclose in the risk factor so investors and readers understand how that can impact the company? And that goes to your question too about boilerplates, right? Because the SEC really does not like boilerplate risk factors, right? It's in their guidance that it should never be boilerplate. It should be applicable to the company and its business. So, for example, let's talk about, there's a risk factor about the Strait of Hormuz closing. How does that impact the company? Are you dependent on energy markets? Are you dependent on that, that fuel, oil, whatever is being transported that is not being able to be transported? Is that going to impact you in any way? Are any other supply chain considerations being impacted by that? So we always need to think about these broad macroeconomic factors and then narrow into the company. How does it impact the company? And then that's how the risk factor is drafted.
Got it. What governance trends are you advising different boards and C-suites right now that you think more reporting companies should be tracking, Gabriel?
I think, and there are topics that are always hot topics, right? I think cybersecurity, conflict of interest, related party transactions and whatnot. But I think a big thing that's been very present now is AI. And, I think that a lot of people, including board of directors, companies, are very excited about AI. And, so am I, right? I think that, for example, I use AI as a tool, right, to assist me sometimes. But, I think that's where the line sometimes gets blurry in terms of how can board of directors, for example, use AI. And one example is, for example, can an AI software take board minutes? I would recommend against that, right? Because we don't know what kind of framework or protocols we have in place to protect the information being discussed in a board meeting, which most of the time can be material non-public information. How do you protect that from being shared into an AI software? How is that going to be kept from the AI software itself or whoever else? So there's a lot of privilege questions. There's a lot of material non-public concerns as well. So, I think that is something that, so board minutes or even board resolutions, you can use AI for that type of thing. But I think it's always good to have a lawyer look at it too, so that we can make sure that all the right resolutions are included. So I think AI has been a huge thing. Privilege has been a huge thing, and how the usage of AI and material non-public information, how does that play out with each other? And it's been a very hot topic, I think, for board of directors, because sometimes, we attend board meetings, right? We take those minutes. And sometimes I think that taking minutes for board meetings, it's kind of an art, right? You want to say the right things, you want to say as much as needed, but there's a way of drafting it that sometimes AI may not pick up. So I think that right now the main thing is just urge caution of AI usage for this type of thing when it involves anything privileged or anything that could be considered material non-public information.
Got it. Gabriel, touching on the topic of AI and future of work, what are the different kind of AI tools that you have been experimenting? Which are the ones that you actually like in your workflows today?
Yeah, so I use Claude. I use Claude very frequently. And I mostly use it as a thinking buddy, let's call it. I use it to brainstorm a lot. I have conversations with it in terms of sometimes I'm trying to think through something and I want to see what they think. And I think one of the most important things about lawyers trying to use AI is to always I'm not even saying double check it, triple check things that come out of AI. And, I think it's a really useful tool for that in terms of like brainstorming. It gives me great ideas. Sometimes I push back on it and it's like, oh, you're right to push back. I omitted something before. So I think it's really important to be mindful that it's not replacing us or our judgment right now, but it can very well be used as a tool. I also use it for, sometimes I need to draft an example, warrants notices, right? There's an adjustment to the exercise price of a warrant and it should be distributed to warrant holders. AI is great to do that. If they have a template, they can throw out 30 of the same back at me much faster than I would have done, manually. So I think the AI is useful. It's not where I'm comfortable taking over most of my responsibilities, but I do use it where possible because I do think it makes us lawyers, number one, I think it's important to keep up with technology. I think that AI is an incredible tool and I think it's going to keep improving, right? So it's important to keep using it and keep testing it and seeing how it fits your workflow and how it fits our job as attorneys. But I think ultimately our judgment is still unparalleled in terms of AI and what we can give executives and board members and accountants and clients and things like that. So I think that, I use it, I love it, but it's something that needs to be used with a lot of caution and a lot of understanding that you have to double check things. And I think that goes to a lot of companies too that, may have an understanding that maybe if you throw into Claude your QuickBooks financial statements will pop out. And I don't think that's necessarily the case. I think it can be used to guide and assist, but it doesn't replace either our judgment or accountant's judgment and real involvement in preparing the financial statements.
Got it. A lot of work that you do today carries a real liability, right? How do you view AI drafting and reviewing SEC filings? And to the broader team, where does privilege, accuracy, and professional actually responsibly draw a line in terms of using AI? How would you want to communicate this to the community, broader community out there?
Yeah, so using even my own firm as an example, we just adopted AI in terms of our usage of it. So we have access to Claude now, and We're working, still internally to make sure we have the right protocols and frameworks and protecting privileged information and all that, right? Because as attorneys, that's our biggest concern, right? We have attorney-client privilege with a lot of the information that's shared with us. So how do we use AI without breaking that, right? So there's been a lot of work internally at our firm to make sure that we can use it in a way that doesn't impact privilege, privacy, and all those things. So it's been a limited use so far. I think that a lot of the mechanical tasks can be done with it, but I think once you start getting to the territory of whether this is material non-public information, privileged, I would caution them to use AI only if you understand how the information is being kept, recorded, and used by the AI software company or whatever itself model, right? So it's still a growing discussion. I think there's a lot of work to be done, right? Generally, in terms of how lawyers can use AI in a way that doesn't impact our privilege that we have with clients. So, for example, I would not necessarily want to throw something that's really, material non-public information that's really sensitive about the company. I don't know if I want to share that with an AI software yet, because I don't necessarily understand how that's going to be recorded and kept by when I throw it in there, right? So I think it's just being cautious of it. If you have questions, ask your lawyer, how you can properly use it, because we are obviously thinking about those things, right, ourselves. So, but I think that a lot of mechanical tasks and administerial tasks, that's where AI shines. I think that's where, where it doesn't require judgment as much. It requires just quick, repetitive work or something like that. I think that's where AI can really shine right now and even more in the future.
What I'm hearing from you, Gabriel, judgment should not leave a lawyer's hand. In terms of the different mechanical workflows that you are involved in, if AI could reliably handle one of your workflows tomorrow, what would you hand it over the first?
Yeah, I think, in line with what I've been saying, just mainly, some tasks don't require the judgment that maybe, for example, when we're working through a disclosure in the MD&A or the business disclosures or whatever it is, right? A lot of times we use our judgment and discuss with management, how much do we want to say? How can we be accurate and transparent at the same time, keeping with management expectations of how much to share? So that type of judgment, I think, still is best kept with the lawyers. But board resolutions, perhaps, those are very straightforward. And once we could, for example, have a model that knows exactly what to say, or even use our templates that we have of board resolutions and use those to draft future ones. I think, board resolutions, notices, transfer agent instructions, a lot of those things that are very boilerplate. It's just a document that says, it's very factual. I think those things AI could take over very easily, which begs the question, right? I think that, for junior associates, how to build that initial experience without doing those things. But that's a whole other conversation, right? But I think that is something AI will soon probably take over in terms of what I do, right? As a senior associate, I can draft resolutions and instructions and all those things quickly, but AI can do it probably in 2 minutes. So once I would be able to reliably do through AI those things, I'll probably do it, and then just obviously always double check either way. But I think that's where it will soon take over. But then, as someone that is a practicing attorney in the community, I would ask, how would that impact the training of junior associates? And I think that's also a conversation that's going on a lot in the industry about how do we balance, right? Because a lot of these junior associates, that's how they learn these things, right? That's their first draft of a board resolution, or doing closing deliverables, right? Which are boilerplate, but in a way it's good for them to understand going through them, or why it's done in a certain way. So it'd be interesting to see how the industry evolves to kind of balance those two things.
Got it. Even internally within our own company, when we discuss about some of these things, and we see a lot of these Slack messages being written out completely by AI, we actually cautiously advise people to actually own up the final outcome of that message. You can have those first drafts using AI. And yeah, that's a problem that has percolated across different work streams right now.
Mm-hmm.
On the parting note, Gabriel, for law students who are right now studying in college and are feeling very uncertain about how the future would translate through, or a junior associate which is realizing a lot of the work that they were doing is actually a one shot away from a Claude or an OpenAI actually executing it in end to end, how should they be thinking about the future? Basis your experience, what should they be focusing on today? Uh, do you see amalgamation of different kind of skills like the one that you brought in through your profile with a uh, setup of law and finance? Should they also pursue something like this? What would be your general advice for people who are thinking too much across in terms of what AI could and could not do, and how should their careers unfold?
Yeah, great question, actually. And I think, a law, it's going to be something that the whole ecosystem of law and, law students and law firms, we're all going to have to probably work on reaching a determination here, because I think that, one thing that I think is important is for law students to start thinking about learning how to use AI. And I think that, I went to law school 10 years ago, but so AI was not a thing, but I expect that a lot of law students are using AI right now in law school. So I think they are learning how to use it, but I think you'll be up for the law firms to want to become junior associates, and they have that those AI skills already they already began using it for legal research or drafting. I think it may be important for law firms to understand this shift and maybe give these attorneys more substantive work early on so that they can use AI, but at the same time do something that requires them to think through it, because that is how you ultimately learn. I think that a lot of law students that will be entering this industry, the big thing for them to understand is to be curious and be proactive and be really just get things done. Be the person that get things done in terms of, AI will make things quicker, but you need to know what you're doing at the end of the day. You need to know how to look at a 10Q. You need to know how to look at a 10K and draft risk factors and negotiate a BCA. And you only do it by doing. You only learn it by doing, right? Obviously. So I think law firms will need to understand that shift, give them more substantive work early on so they can start thinking about these things and start learning it, because they'll be using AI for the mechanical things. We may not need them to do those things anymore, right? And circulate signature pages. AI will be able to do that, right? So I think they'll need to start thinking, law firms need to start thinking about giving them more direct experience early on so they can start learning. And I think law students and junior associates need to be proactive about getting some of that work, some of that exposure early on, because I think that, they can't only rely on what junior associates have done in the past 10 years. I think their experience is going to be vastly different. And I think you'll be up for everyone in the ecosystem to really get together and find a way that makes this work as AI keeps evolving. You see law firms themselves are, creating their own AI, for example, right? So there's going to be a lot of AI improvement in the next few years. And I think law firms will need to I think they need to be the ones catching up at this point in terms of how to balance the AI usage and AI growth we've had in the last 5 years or so versus, how to teach these junior associates how to be a corporate attorney and not just an AI prompter. I think it'll be interesting to see in the next few years. I think we're seeing these AI models becoming incredibly powerful, every month almost, right? So I think it'll be an ongoing process for everyone involved. But I would just say for law students and junior associates, just be curious, be proactive, try to learn what you can. I think that with AI in your hands, you can even learn quicker through AI, but always double check things. If AI told you something, go do a form check on a Form 10Q. If AI told you something is in the agreement, go check the agreement. So, and that is one way they can also learn, because I think that, they can use AI to kind of give them maybe a summary of something, but then they go into the substance of the actual document and learn by reading and understanding. So it will take some adjusting, but I think it will drive the industry for the better in terms of efficiency and whatnot.
Awesome, Gabriel. Thanks for taking out time and sharing your words of wisdom with everyone in the community. Have a great weekend.
All right, Gana, thank you so much for having me. And, I think that this industry is such an incredible industry to work in. So I think that for anyone interested, of course, they may have my contact as well, so they can reach out. And obviously, if anyone watching this has any questions about your own density reporting or anything like that, Mitchell Stuebelberg and Up, MSK is the firm I work at, and we'd be happy to have a conversation. So thank you so much.
Thank you, Gabriel.